Gabriel, você deve ter participado das outras plenárias. Como é que está a participação do público?
Olha, nós temos 1.116 pessoas inscritas. Mas, ao contrário do que ocorre no Congresso presencial, em que a pessoa está lá no evento, acaba assistindo sempre alguma palestra, com esse sistema à distância, a pessoa que não tem um interesse muito claro numa palestra, simplesmente desliga e vai cuidar da vida. Então, nas plenárias, a gente tem tido 200, 300 pessoas, nos painéis 100, 120 pessoas. Agora, a vantagem é que tudo fica na plataforma gravado para assistir depois. E aí, a técnica tem muito acesso no mesmo dia e no dia seguinte das pessoas interessadas na palestra que não conseguiram assistir, né? Hoje eu prevejo que para nossa devemos estar nessa linha entre 200 e 300 pessoas. Vamos ver.
E como é que é a dinâmica com os participantes? Eles podem fazer pergunta pelo chat? Não, né? Não tem chat.
A gente tem sempre uma plateia VIP que a gente não vê, mas eles podem mandar mensagens. Eles não aparecem também.
Mas o palestrante, nós podemos ler essas mensagens aqui no nosso Zoom aqui? Elas aparecem para a gente?
No chat, em teoria, deveria aparecer. Agora você me pegou, agora não tenho certeza.
Mas o participante comum, ele não tem condição de mandar uma mensagem no chat?
Não. Agora, o que tem ocorrido, na verdade, Enzo, é que 9 em cada 10 sessões não sobra tempo para pergunta. Essa que é a verdade.
Receio que a nossa vai ser nesse caminho.
Pois é.
Finalzinho do evento.
Olha,
eu participei agora de manhã de um table topic com o desembargador Lazarini.
Eu não consegui assistir nada.
A gente teve de manhã um table topic sobre jurisprudência do STJ com o desembargador Lazarini, de Câmara especializada no TJP. O Marcelo Leonardo Tavares, juiz do Rio, estava participando. E pouca gente, um debate super interessante, alto nível. Mas eu sei que muita gente acessa depois. Entendeu?
Tá bom.
Eu sou uma das que acessa depois. Eu até assisti uma parte dessa mesa de manhã, mas eu não consegui assistir toda e assistir depois.
Aliás, o melhor resenhador do Congresso é o queridíssimo Antônio Abrantes, examinador do IPI, que a cada palestra ele posta detalhadamente um relato do que foi debatido com muita fidelidade. Ele faz isso no grupo de patentes e comentários que ele mantém no Facebook, né?
É ótimo.
Olha, quase 2.000 membros do grupo já, Márcia, impressionante.
Boa tarde a todos. Chegamos ao quarto e último dia de nosso evento, após uma rica manhã de debates acerca da propriedade intelectual. Convidamos agora todos a assistirem nossa última plenária sobre os 25 anos da LPI e sua modernização. Antes de iniciarmos, vamos proceder com a entrega do prêmio Patente do Ano, fruto de mais uma parceria da ABPI com o INPI. Passo então a palavra ao nosso diretor conselheiro, Ricardo Boclin, para conduzir nossa cerimônia de premiação.
Olá, boa tarde a todos. Bom, eu aqui em nome da organização do Prêmio Patente do Ano, agradeço a academia do INPI, e com a sua isenção e qualidade nos ajudou bastante nesse processo pelo segundo ano. Eu queria agradecer aqui, em especial, ao pessoal da academia, o Celso Lage, o Ricardo Rodrigues, o Daniel França, e, mais especial ainda, queria agradecer a comissão julgadora, né, que foram formada por 3 professores da academia, que eu vou nominar aqui, seria a Rita de Cássia Pinheiro Machado, o Alexandre Guimarães Vasconcelos e a Adelaide Maria Antunes, que foram os que escolheram a patente vencedora. Eneida, você quer passar a palavra para o INPI?
Bom, eu primeiro queria agradecer a BPI, né, por ter nos confiado essa missão, né, Ricardo, de organização e coordenação desse prêmio, do segundo prêmio de patente do ano, que esse ano tem o tema, né, com o tema que contribuíram para o desenvolvimento econômico sustentável, que estão contribuindo. Então, eu passo a palavra para o Dr. Júlio César Moreira, diretor de administração do INPI, que fará essa entrega. Júlio.
Boa tarde a todos. Na verdade, é o segundo ano, quando o Ricardo falou aí, desse prêmio Patente do Ano, e nós aqui do INPI estamos muito orgulhosos de participar e contribuir junto com a BPI nessa premiação. Está sendo premiada a melhor patente destinada ao tema do desenvolvimento econômico sustentável, né, da economia circular. Eu acho que isso é muito importante. O objetivo aqui do nosso trabalho é premiar o trabalho de profissionais e empresas que reconhecem a importância da propriedade intelectual e buscam a proteção no Brasil das suas criações. Isso é muito importante. Essa iniciativa, obviamente, não poderia deixar de contar com o apoio do INPI. Nós analisamos as 10 patentes qualificadas e, através da comissão julgadora, que o Ricardo elencou aí para a gente, ela partiu do seguinte pressuposto, seguintes quesitos, para poder fazer a análise da patente que seria vencedora desse segundo prêmio. Foi o potencial para a geração dos benefícios sociais, o impacto ambiental, o potencial para a geração de benefícios econômicos, a internacionalização da proteção, a abordagem de gênero e a participação de inventores brasileiros. Ao final da análise, a vencedora deste prêmio do ano de 2021 foi a patente de invenção intitulada Aditivo Antiformação de Poeira, processo para fabricação do aditivo antiformação de poeira, uso do aditivo antiformação de poeira, método para reduzir a emissão de poeira de fertilizantes e método para reduzir a emissão de poeira na indústria de mineração. Tendo como titular a Cargill Incorporated e como os inventores o Hélio Itsushima e Ricardo Chagas da Silva. Parabéns aos inventores.
Eila, você gostaria de falar em nome da Cargill?
Sim, muito obrigada primeiramente, né, agradecer muito, é uma honra estar aqui representando a Cargill nesse evento, é uma honra ter participado da premiação de patente e muito mais ainda, né, ter sido reconhecido como a patente do ano. Falo em nome da Cargill Agrícola S.A., que é a Cargill aqui no Brasil, e também em nome da Cargill Incorporated. Estamos aqui falando de uma premiação de uma patente 100% brasileira, e inclusive para dentro de uma empresa norte-americana existem também seus desafios, né, de demonstrar o quanto a nossa região é capaz de inovar. Então é extremamente gratificante ter recebido esse prêmio, né, ter participado, ter disputado. Eu gostaria de agradecer ao escritório Gaiarsa e Meyer, que nos apoiou desde o início, em memória também do Dr. Lucas Gaiarsa, ao Ricardo Chagas, Hélio Shijima, que são os inventores aqui dessa patente, mas sem dúvida nenhuma também ao INPI, à ABPI, à academia do INPI. Muito obrigada por essa premiação, representa muito para a nossa empresa. Eu vou passar a palavra para o Hélio Shijima, o principal inventor aqui da invenção patenteada e campeã, né?
Obrigado, Eila.
Of the winning patent. For me, it's a great honor. It's a great pleasure to participate in this event. It's very rewarding representing the company in receiving this award. It represents the commitment to innovation to sustainability. We use industrial byproducts to create value solutions to other industries. And in this case at hand, byproducts have been used to develop a dust suppressor for the fertilizing industry, creating a closed circular economy where agricultural feedstocks from sugarcane and corn are transformed in other products and go back to agriculture, contributing to reducing losses in feedstocks. At the same time, these byproducts are no longer wasted. We reduce greenhouse gases, the use of water, and today these products are fertilizing crops around Brazil. Brazil has this agricultural talent. There's no doubt about it. As a message, I invite you to look at industrial byproducts. You may be faced with valuable feedstocks to create value, to reduce environmental impacts, and to contribute to sustainability. And finally, I'd like to thank Ricardo Chagas, Marconi Vieiras, Katia Elamota, Paulo Hoffman, all those people that have supported and have contributed for the success of this project, but are not present here today. Thank you wholeheartedly. Now, Ricardo, you have the floor. Ricardo Chagas. Well, I'd also like to thank on behalf of Cargill for participating in the award. As Ayla has put it, for us, it's very challenging to show our potential, our creative potential. So this award is very important. It shows the Brazilian potential in creating and innovating. I think this initiative is very important, and it's important in valuing intellectual property. Thank you so much, Ayla, and everyone who has supported. Thank you so much. First of all, congratulations to Cargill for the award. Julio was the one who actually signed the letter patent. He is the patent director at the Brazilian PTO. Your award is going to be delivered at a later stage. We couldn't do this physically. We don't even know where you're going to receive the physical award, maybe at home. And now I give the floor to Erica to start with the final plenary. Congratulations, everyone. Thank you so much. Thank you. We are now going to continue with our agenda. Plenary number 4, 25 years of the law of protection of intellectual property. We have the honor to receive Gabriel Leonardo's partner at Cosnar Leonardo's. I am touched by this award. It's fantastic. Congratulations to the winners, and thank you so much to those that have participated in this initiative. We are slowly nearing towards the end of our Congress this year. We have learned a lot, and we still have a lot to learn during this session. We're going to have 3 presentations. I know they're going to be fantastic because I have seen their PowerPoints. So I would like to wholeheartedly greet everyone. I would like to thank you for your availability and participating. The order of presentation, I am going to make some initial comments. We're going to hear Professor Enzo, after that Felipe, and then Marcia. And then hopefully after these presentations, we might have a little time for Q&A and debate. At ABPI, we understand there are a number of provisions in the industrial property law that should be changed. We're working on a bill to offer the country with the aim at creating a legal conditions to a leap into a technology that will generate social and economic development. We have a lot of legitimacy, not only as the main entity for intellectual property in Brazil, but also because we are the authors that drafted the bill that resulted in the Industrial Property Act. At the time, we were going through some transformations. The federal government decided to change the law to have patents for pharmaceutical industry. But at the time, there was no consensus as to the drafting of a new law. So ABPI, through the members throughout over a year, has carried out meetings and approved a bill offering to the federal Congress that have been embraced by congressmen, and with some changes ended up enacting Law 9279. From the amendments, one of the amendments was the pipeline patents. That was not part of our initial bill. We avoided taking position in issues that are more politically sensitive. So, but this is the role of the National Congress, and they introduced that amendment on our bill. So apart from small alterations, what was approved, what was we drafted at ABPI. So 25 years later, we now are in a position to know what was good, what was right, maybe could have been better worded, and then also what has changed in this 1994, 95, 96, when we drafted the bill, we were still starting with internet. It was in 1996, the first time I dialed to get access to the internet, and we could not fathom what evolution we would see just in a couple of decades. So political negotiations are not risk-free. There's always a possibility of National Congress approving amendments that will end up not stimulating innovative initiatives from companies. One example is a bill number 12 that has been approved by National Congress. The president should be vetoing or approving it by the 22nd of September. Facilitating compulsory licenses in cases of tragedy, emergency, and public interest. It changes the Article 71 of the law, which, in my opinion, in a way as if the executive power was incompetent. It creates hypothesis that compulsory license is going to be granted regardless of the convenience approval by the executive power. We believe that this is not necessary. We already have a law that allows for that. I have an article that I published defending this instrument for the balance of the system in international since 1925, when the concept of compulsory licensing in the review, the Hague review of the Paris Convention. This bill sends a message, a hostile message towards patents to innovative companies. I was representing ABPI in Brazil at the Congress, and I realized that we can say that that are good reasons for defending it, but what there is a prejudice against the patent system. And then at ABPI, we believe the opposite. It is the patent system that is going to make sure that social and economic development is going to happen in this country. And that's why we hope that the bill is vetoed, although we think that it's always possible for Congress to overturn a presidential veto. Another bill is 10-9-20-2018. It was submitted by Julio Lopes and Abiaco, congressman. It was to implement the Madrid Protocol. It has been changed by Congressman Freire, the Democrats of the state of Paraíba. He has dedicated a lot of time to intellectual property. You have to recognize that. It's relatively rare that we have congressmen or senators that really look after intellectual property with care. And there's a positive point in the current wording, simplifying the service of process of foreign companies, but creates a provisional patent institute. The law already allows for that. We believe that this should be open for debate. Is a bill that needs our attention. We are not favorable, not against it. We just believe we need to debate it further. And the bill has already been approved by the lower house, and now it's under review of the Senate. Article 32 of the intellectual property law treats awarding of patent applications. This is usual around the world. We understand that ABPI, once it's understood, amendments of applicants should be accepted by the Brazilian PTO as long as submitted before the end of appeal examination. Today, it's already restrictive. It demands that amendments be submitted before filing. Today, there is an action against the Brazilian PTO. This has been denied in the first court level. Now there has been an appeal, and the prosecution office wants to further restrict the voluntary amendment submission. The bill I have mentioned tries to improve the wording of Article 32. But we still believe that is not enough. You have to remember, it is mainly national companies that most need the prerogative of being able to improve wording of the patent application, as these amendments are submitted around the world. There's no point making it impossible here. Some argue that this is what makes the delay in the examination of a patent application. What makes the delay is the lack of instruments caused by successive administrations in recognizing the financial autonomy of the Brazilian PTO. This is a topic we have repeated many times. and that should generate more indignation of all those that are worried about the patent system here. Finally, there are two bills that we support because they seek better skills for the Brazilian PTO. Two bills. One of them is under a commission at the lower house, and it has been approved by a financial and taxing committee. It says that the budget, the changes of budget in the Brazilian PTO, and there's another bill we also support to introduce changes in law 9279 in order to confer the Brazilian PTO control over its budget. Because this is part of the law 9279 and the bill is just refining it, then we have a complementary law bill to avoid the criticism that the right legal way would be a complementary law. But these two bills receive our support. In its original wording, it was only determining a maximum amount of time for the Brazilian PTO to conclude the examination. Now it has been changed by Congressman Laércio Oliveira and thank God this has also been approved. So this are the bills that are relatively advanced in the lower house. But as we spoke before we started, when we open the possibility of amending a law, you are opening a Pandora box. Everyone will contemplate a number of changes. And this is the kind of initiative that we are going to discuss today with the presentations we are going to hear. And to start, we are going to have dear Professor Enzo Baioca. He's a professor of trade law in the University of the State of Rio de Janeiro, where I had my degree, and then in the Federal University of Rio de Janeiro, where my daughter had the honor to graduate. He's also a professor at competition law, intellectual property law. He has a university degree from a university in Munich, where I also had my post-graduation, and he has a PhD in philosophy from the State University of Rio de Janeiro. He is a member of the Commission of the Intellectual Property at the Brazilian Bar Association, and he is academic coordinator in the Simmons Institute. Then we are going to hear our dear Felipe Augusto Machado, General Coordinator of Economy 4.0 of Intellectual Property of the Subsecretary under the Secretary of the Ministry of Economy. He has a degree in International Relations from the Federal University of Rio do Sul. He has a degree in Strategy and Development from the Center of Strategic Studies and from the National and Public Administration University. He also has a Master in Public Policy from ABPI. And finally, we are going to hear dear friend and a frequent participant of ABPI, Marcia Maria Nunes. She is a judge at a specialized court in intellectual property. She has been a head judge there since 2001. She has a master's degree in public administration, has emphasis in innovation, intellectual property, and development from the Economy Institute of the Federal University of Rio de Janeiro. She is part of the Technical Council of Research and Exchange of the Federal Justice Council. She is a professor at the Magistrate Academy. I can say that she is hardworking. She studies a lot, And it's a great pleasure always for lawyers, intellectual property counsels and lawyers, because she issues judgments that are very careful and unprecedented in Brazil. If any lawyer works with her in cases, we double our efforts, because we know that our petitions are going to be very carefully read. With the dream team of experts, we are now going to start debating possible amendments to the law that is now completing 25 years. Professor Enzo Maiocchi, you have the floor.
Obrigado, boa tarde a todos e a todas. Inicialmente, gostaria de agradecer meu querido amigo e colega de profissão, Gabriel Leonardo, não só pelo convite, mas pelas palavras amigas também. Quem tive uma honra também de ser professor da sua filha na Faculdade Nacional de Direito, a FRJ, e eu gostaria também de felicitar meus colegas que compõem essa mesa comigo, doutora Márcia, doutor Felipe, e dizer que é uma honra muito grande poder estar nesse evento e, de alguma forma, sua perspectiva do mundo da academia, contribuir para o aperfeiçoamento da nossa lei, que já está completando 25 anos, e, sem sombra de dúvida, como o Gabriel já pontuou, é mais do que um momento de pensarmos com profundidade no seu aperfeiçoamento, na sua alteração, sempre visando o interesse de crescimento, de desenvolvimento do nosso país. Eu vou compartilhar aqui a tela com a minha apresentação. Espero que vocês já estejam vendo. Já estão vendo a tela aqui já?
Sim, estamos.
Só um minutinho, então. Deixa eu botar no modo aqui. Está no modo tela cheia. Ótimo. Bem, vamos começar para não perder muito tempo.
So let's now start. I've started in this presentation to concentrate in only one point, knowing that my two colleagues will give you a more comprehensive presentation. I would certainly have other provisions from the IP Act that we could discuss and we could suggest improvements, but I've tried to concentrate on one provision which I believe, in terms of distinctive signs of our IP Act, I believe that since its enactment in '96, the result has not been satisfactory. So I'd like to focus on this particular provision to see how this is debated in the doctrine, in the academic field, how it has been received by the courts and by the Brazilian PTO. And I will show at the end of my presentation the bill that is being discussed in Congress. And as always, I also have a suggestion for the improvement of this provision. And by doing so, I expect to provide a humble contribution to this debate. I'm sorry to interrupt, but I'm being told that only the English audio is being heard.
Creio, né?
Mas eu acho que a pessoa pode escolher o áudio em inglês, não? Ou foi talvez um erro da técnica?
Agora estão dizendo que está ok.
Pronto.
Desculpa isso. Desculpa interromper.
This is the English translation. Sorry to interrupt, but there's been a problem. Well, Enzo is so talented that he speaks in Portuguese and it automatically goes into English. Well, this is certainly an issue that if you're a lawyer, if you are a judge, if you work in this area, you're very familiar with it. And I ask your license to, I ask you to go back to some aspects so that we can reach the following conclusion. From the theory that I'm going to present to you, very little is left, and I'm going to anticipate here a conclusion that I will present at the end. I start quoting Rui Barbosa, who in a very straightforward manner touches on the essence of this institute, regardless of the name that we may attribute to it. Reputation. Reputation is responsible for the trademark, and the trademark guarantees clients in such a way that clients follow the reputation and the trademark, and buyers oriented by the reputation see in this brand the mark of the sign of excellence. So I thought this was interesting because it is precisely what we have in this context, which aims at protecting clients, protecting companies. And there are some issues that I believe to be addressed. I ask questions in this slide, and as I go along in my presentation, I will debate each one of these questions. The first one is the most obvious one. Why should we assign protection to a distinctive sign, to a trademark? And what is the ratio essendi of this norm? And I am referring to Article 125. What are the categories of the special protections and the trademark functions? What is the history of this type of protection in the law? And what is the background in our Brazilian patent and trade institutions, and what would be the adequate legal treatment? And that's how I'm going to conclude my presentation. So why to assign special protection to the trademark? There is a quantitative approach and also a psychoeconomic one. And here we talk about image and how to transfer it, transfer of brand images. So there are three distinctive functions. One, which is the distinctive function, which is the main function that the trademark must have. The other one, which is economic, and the other one, which is aimed at advertising. And this one of advertising, of disseminating, it focuses on the function. It is the link between the holder of the mark and the consumers, and therefore the transfer of meaning in terms of values, lifestyles. The attractiveness of the sign takes us to another aspect, which is the economic function. The economic function reflecting the investment of the holder and the dissemination of greater knowledge among the population, more prestige, and therefore trademark becomes an intangible asset of great value. This type of protection is thus recognition of the trademark holder, recognizing the investments that have been made. And here I'd like to present to you a provocation in terms of the quality of a trademark. Is there a quality function? Do trademarks have such a function? Do they ensure quality of a product or service? And this is a provocation, as I said, and it's an opportunity to think about it. I have a critical view on that. I think there's a difference between stating that the mark has a quality function, because we know that the modern industrial economy, there are many issues and many aspects of the consumer's rights which are not related to quality. What we see today is program obsolescence and also massive recalls. So when we talk about this quality function of the trademark would ensure quality. Well, in my opinion, this quality should be interpreted as an indication of quality. And I would use the plural here. It is a suggestion of certain characteristics that exist but will not ensure quality. So this is the first idea that I would like to present to you. And the symbolic effectiveness. So trademark versus status. And this is what the advertising function performs so well. And there's again the vulnerability in terms of counterfeiting acts. The special protection is based on the assumption that the higher the reputation or the distinctiveness, more vulnerable this trademark will be, because this trademark can be reproduced, or there can be emulations. So that's why a special protection is deemed to be necessary. Given these initial considerations, the next question is, but what is or should be the ratio essendi of this norm? And here we have in the doctrine, in the Brazilian doctrine, but also in the international doctrine, we see many justifications for this type of special protection. The first one, which is related to the very origin of this institute that dates back to 100 years ago, and which is mentioned in item 1, this is related to the good performance of the holder of the trademark in terms of competition. So competition based on a good performance of the trademark owner. Another justification would be protection for the asset per se as an intangible asset. It's also an investment in marketing and advertising. In addition, there's protection to the trademark functions, especially distinctiveness, the economic and advertising functions. Therefore, avoiding the dilution of the attractiveness of the signal. But in order to get to this point, to consider that the ratio essendi is this one, it must be very clear what are the functions of a trademark. With free competition, what is the function that a trademark will have? And also, we have to address the unjustified parasitic use of the economic value of a trademark, what we call the goodwill, and also the situations in which there is free riding. And by doing so, we can avoid a deviation of the original clients of that brand. And also, how to prevent interference in terms of a freedom of choice in the consumption market. This is just a summary. We could look for other aspects, but I just wanted to highlight the main ones. And very few of these considerations have been incorporated in our legislation, and none of them have been incorporated in Article 125, which is an article about which I am particularly concerned. And we know what are the effects of all that. It's the lack of specialization. There is a relief which is extended in terms of the market, and we are outside the field of similitude between products and services. So it's an exception to one of the major principles, which is the principle of speciality. Another question that I would like to ask you, but what could be the limits to this special protection? Once we assign a special protection, as we're going to see in Article 125, and it's an absolute protection, this absolute protection should find in our fundamental rights in our constitution some type of limitation, and we don't have that in our legislation. So this is an additional point that we should be thinking about. And these limits here, and I could mention what could be these limits, is the social function, the protection of consumers' rights, and freedom of choice of consumers, the freedom and the possibility of not being led into a misleading situation, therefore free competition as well. So these would be the aspects that I would raise in response to this question, but I'm going to be dealing with that further during my presentation. So this special category of trademark is not recent. It is addressed in 3 different codes. We have the Industrial Property Code in 67, 69, and 71. In 71, because it's the most comprehensive, I have here one article so as to call your attention to this article, comparing it to what existed before. It says that a notorious trademark in Brazil will be given special protection in all classes with a special, with certain specialties in terms of its origins, the origin of products, and as long as there is a possibility of a misleading interpretation, or if there is any loss for the reputation of the trademark. And I am highlighting this last line because in other acts and in other legislations, and I will mention here the trademark legislation in Paraguay, which is very advanced in terms of assigning protection to the famous well-known marks, but also in the European legislation we see that. In terms of the European Union, we are going to see that these elements are also considered. With Article 121, nothing happens. It says that marks registered in Brazil should be considered to be famous, and once this is done, if they are considered to be famous, they will be guaranteed special protection in all fields of activities. So this is a highly market-oriented approach. That's what we have here. Here I engage in a critical analysis of this norm. It's a new law, a new LPI, a new system, so we should not get it confused with the well-known marks with what we have in the previous legislation. There is a full rupture with what existed before. There is here a new approach in terms of protection, and it's new in terms of the normative structure, in terms of the text of the legislation of the norm. And I also call your attention to the legal effects, which also impacts the principle of speciality. Article 125 protects absolute protection to the famous nature of the trademark. And this goes back to what happened in Germany in the beginning of this century, and I have here the name in German. So regardless of a proved evidence in terms of any misleading interpretation in terms of origin, and this also has to be referred to the previous legislation. Now, it's not emulated, self-emulated. It has minimum requirements. It has to be registered, and it has to be considered as a well-known mark. Because it is a general norm, it needs to be regulated, or in this, according to the theory, we should have an individualizing intervention on such cases. So from the time the IP Act was sanctioned and became effective to this period, many years have elapsed, and therefore there was a period of uncertainty in terms of the practical application of Article 125, and many lawsuits were filed aiming at this recognition in our courts. But afterwards, in terms of the jurisprudence of our courts, it was concluded that that this was not necessary. This declaratory action was not necessary, was unfounded. Therefore, we had an administrative procedure at the Brazilian PTO. And I give here an example of a leading case, which was the starting point to the first resolution for well-known trademark. This has taken the Brazilian PTO away from the inertia environment in which it was from 1996 to 2004. And that's the uncertainty period that I talked about, during which there was legal uncertainty and lack of security. And this was due to this very open and generic drafting of Article 125. Now, the IP Act has existed for 25 years and 17 years of resolutions, and also several approaches that have been adopted. There are at least 5 resolutions from the Brazilian PTO in 2 decades. So it's 1 resolution at every 4 years. We have here some statistical data showing how this is presented by the Brazilian PTO. It may have been adjusted lately, but data that I'm presenting here is from this year, 132 famous trademarks, and 100 have been allowed, and this is the number of the trademarks below that have been rejected, 174. And we have here the resolutions, first in 2004, and it had an opinion, as I present here in the slide, and other resolutions followed. 121, resolution 23, which is just renumbering resolution 121 from 2005, so same resolution, just a different number. There are no major impacts for whoever works in this area, but it does bring confusion. So we have 2 resolutions that actually mean the same thing. It was just a change in numbers. But when you compare dates, 2013 and 2005, this may bring about a difficulty to those who are unaware of this detail. And the resolution, which is effective until today, 107, but it has been amended by a resolution dated 2016. So we have 5 resolutions, at least 5 different numbers in 2 decades since the effectiveness of the IP Act. 1 resolution at every 4 years. And I will show shortly a comparison of these changes that have been introduced by the Brazilian PTO. If you are not familiar with this system, and I think most of you are familiar with that, but anyway, I wanted to show this. Here we have past, and here I am talking about the 3 industrial codes, and I give more emphasis to the one from 1971, and the watershed was certainly the effectiveness of TRIPS and Article 16.3, which made the situation of a special protection given to trademarks even more relevant. Here, 1996, we had no requirements or competence, so the system would change completely what we had in the previous system of 1971. It does not introduce requirements unless this trademark is registered in Brazil and is deemed to be a well-known trademark, nothing else. And it does not establish the competence of who is responsible for recognizing the fact that it is well known. So we've seen in the jurisprudence that there is an understanding that the Brazilian PTO would be responsible for that. Then we have another period until the first resolution in 2004, 2005. The system is again changed by the Brazilian PTO, and 17 years after the first enactment of the IP Act, we have the resolution which is effective today and which significantly changes the previous system which had been adopted until then. This is just an illustration. It's a certificate showing that we have here a 10-year period of protection. And what would be the future? What is the upcoming evolution of this article? We have a bill which has already been sent to the Commission of Justice and Citizenship, and I'll be talking about it shortly. And now we also have a proposal, a draft bill developed by the Brazilian PTO, and I believe and I hope it will give a greater contribution than this project that is being recognized, being discussed in Congress. And so, unfortunately, I have to ask you to reach your conclusion in a few minutes. We are a bit concerned about time. Dr. Felipe has already told us that he will be forced to leave at 4 p.m. and we don't want to miss his presentation. So just a comparison, and it's just an illustration. It's very easy to compare what was the previous system adopted by the Brazilian PTO and how it's done today. This has been published, and I've worked together with another representative, and this will be made available to you. This will be published. And let me now turn to the 107 resolution that presents 3 fundamental requirements, and they are subject to criticism, in my opinion, especially this the fact that the well-known trademark is here linked to a recognition from a great number of people in the population. I think this is misleading. The second point is quality. We didn't see that in the previous legislation. We didn't see that in 125, and the trademark functions are not highlighted, but all of a sudden we have that. And here, my proposal is the inclusion in a very precise and clear way of new concession requirements. And this would be minimum requirements so that special protection could be given under Article 125. The regulation of this recognition of a well-known trademark is important, and also the fact that the holder of the trademark should contest and have recognition not only in the scope of the Brazilian PTO, but also in our courts. The third point is the lack of need to have a specific registration. And the question that I would like to leave with you is the incorporation of Article 16.3 from TRIPS that I believe has not been implemented in Brazil, unlike what happened in Paraguay. So I suggest that we compare the existing legislation to see what other countries and other legal systems have done in terms of the well-known trademarks. Well-known trademarks is a sign of a cosmopolitan approach. We have economic groups, national and international, that rely on that, and they are both of them, they both have an international presence. I have highlighted here a few words, which is an incentive for a critical evaluation, critical review of Article 125. This is the current draft amendment. It has already been sent to Senate. The Senate has included other amendments, and we have a favorable opinion from the rapporteur. And this is under the scope of the Commission of Justice and Citizenship, and I believe this will be approved. But my question is, once we read this text, this is the text that came from the Senate floor, and that is being already approved in the House. My question is, does it respond to the ratio essendi of the norm? Does it contemplate an effective protection of the trademark functions? Is it in line with our history? And does it provide a legal treatment which is appropriate and reasonable? So these are the questions that I would like to leave with you. And my advocacy here is that we should include an updating. It's more than time that we change Article 125 so as to alleviate the pressure that is now in the hands of the Brazilian PTO. We've seen what the sequence of resolutions has brought about to the institution. The Brazilian PTO at each resolution was changing its perception. So there is therefore this very significant pressure, and we have to find a balance between the different interests. We have to see what is the function of the mark in the competitive market and the free market. We have two very interesting points, which is free competition and protection to consumers. Going back to what I've said before, and if we are to compare the existing legislation with what exists in other countries, we should have a restrictive interpretation of Article 125. And what do I mean by that? A real possibility of damage to the trademark functions, real possibility of risk of confusion or association. The use in trade, it could be a free riding type of relation, or the identical signs or signs that have a very significant likeliness. And going back, free competition and protection to the consumer. These are the pillars that have to be protected. We are dealing with an interest which is the interest of the holder of the trademark, and we are doing that directly, but indirectly, we have to consider the consumer. Thank you, Gabriel. I hope that I've responded to your question. Professor Answer has given us a masterclass about this fascinating topic. We could devote the whole conference to this topic, but here we have different audience and we are very flexible. And in order to do so, we are going to hear now Dr. Felipe Augusto Machado. He has already been introduced. He is from the Ministry of Economic. Once again, I'd like to thank you the invitation that was our invitation to come. We are very happy to be able to rely on your contribution for the ministry. Thank you.
Thank you very much, Gabriel. I'd like to apologize to Professor Enzo. I didn't want to be to blame in reducing his time for speaking. He was actually really giving us a fantastic class. So I start by apologizing to him. I'd like to congratulate ABPI through Gabriel. This has been another fantastic Congress. I'm sure that all participants have enjoyed the panels and all the plenary sessions. We have learned so much.
Vou fazer aqui compartilhamento da minha apresentação, que é uma apresentação.
I am now going to share the screen. My presentation is going to be brief. I am going to bring the perspective of the Ministry of the Economy, what we have to add in our experience throughout the years with the contact we have with the various intellectual property stakeholders, as well as in our international negotiations. As you know, establishing free trade agreements, free trade agreement plus has been occupying the agenda of our government in the last few years, and that then puts us in contact with the areas, and especially when it comes to intellectual property legislation, and we end up having access to important information that we can share here when we want to talk about intellectual property law in Brazil. I think out of the dream team here, I'm only the guy who carries the piano. I definitely am definitely not at the same level as my fellow speakers. So the fact is that in the last 25 years, the technology transformation has been incredible. We can say in this sector, at the time when we used to see films in THS, now it's all about streaming. We had floppy disks, now it's in the cloud. So obviously technology progress that is huge will definitely impact a number of knowledge areas and a number of regulation areas, and it wouldn't be different when it comes to intellectual property, maybe especially in intellectual property area, as we're speaking about an institution that is crucial for the development of technologies and innovation. So this discussion from our point of view is very welcome. We know that legislations cannot last forever and work in all eras. I need to mention the intellectual property national strategy was launched last year. It was a result of a comprehensive debate with society, civil society, academia, private sector within the government, and it ended up generating conversations with over 200 experts. We have received many contributions through public interest consultations, and then we are very proud to have this strategy. And actually in the month of August now, it started with the first action plan for 2021-2023. So we have X4, which is dedicated to the modernization of legal frameworks, including the intellectual property law. The idea is to bring legal stability, try and fix some construction issues we have with the intellectual property law, simplify and make processes more agile, facilitate access to intellectual property, and make sure there is respect to intellectual property rights. The GIPI, which is our executive secretary, is going to coordinate the debate with society, with academia, so civil society, and the various government bodies, as well as the other powers. I think Gabriel spoke about the importance of Congress and everything related to regulation, and especially when it comes to implementation of a new intellectual property law. So this discussion is essential, and we need to involve all stakeholders that are part of the intellectual property system. Another aspect that we see with positive eyes, and that was mentioned by Gabriel in the beginning, is that ABPI is working on a bill, and we're available to help in whatever you need. It's very important that we conduct a comprehensive debate on the topic, and here we are at GIPI. We are available to participate in the debate, and I'm sure we're going to make headway with this discussion. I am going to speak about a number of reflection points. As I said, so many people have accumulated so much experience in the last few years, and here there is no firm position. The idea is here with this presentation is to stimulate reflection. We're not going to establish any proposals for changes or anything like that. Just going to bring up some points that have been brought to our attention that could be the object of a more profound reflection. The first thing I'd like to talk about when it comes to patents is establishing technological standards. This is a heated debate, even internationally, especially when we speak about technology and whatever emerging technologies, but telecommunications most especially. This is a major struggle internationally. National states often react with some aggressivity when it comes to these standards to fight for their companies' technologies to be used as international standards, because then it's an advantage when it comes to power to establish a technological pathway that we call the first movers. The pioneers will end up having an edge when it comes to invitation, because the technology pathway chosen is the technology that that company or that nation dominates. So this ends up fending off other technologies from other companies, and this is a heated debate geographically. So this is what we've seen in international debate. On the other hand, authorities, national authorities in competition, antitrust authorities say that we need to make sure that we have enough competition for innovation, and then the licenses for these should be done in a fair, non-discriminatory terms and condition. and this has been debated in this Congress. This is a very heated debate that can eventually may go into consideration for amending the intellectual property law. Something else I'd like to mention is software, computer software. They are usually not patentable. The law in 99 established that softwares could be protected based on copyrights. So this is a technical discussion, very interesting discussion. Would it make sense for us at this point in time to make softwares patentable? Today is possible, but only when embedded on a hardware. So then the invention characteristics under Article 10 would be present. So this is a segment that is fast moving. In practice, updates, software updates that are part of our everyday life may end up that protection through patents is not going to be so effective. At the same time, there are people who criticize, stating that there are limitations to copyright because it doesn't effectively protect the processes and products of a source code. We can have two softwares with two source codes in two different languages, and this may end up hindering protection that companies or the individual is seeking. This is a discussion that should be also part of the debate when considering changes to the intellectual property right. When it comes to emerging technologies, the patents created by artificial intelligence, is there a maturity to discuss this and place it in the law? At the Ministry of Economy, we follow a number of bills that are running in the lower house in respect to artificial intelligence. And we know that there's one that should be voted by until the end of the year. And there is sort of consensus around this point that maybe there isn't enough maturity, not even to regulate more broadly the application of artificial intelligence systems. Knowledge is not mature enough here or elsewhere abroad for us to know the negative and positive impacts. So there are a number of questions related to non-discrimination, democratic values. Basis on around artificial intelligence is more in the sense that these bills should wait a little more. So we're waiting until the end of the year, maybe at least not at this point in time. Maybe is maybe not so recommended to include, at least at this point, anything related to artificial intelligence. As for trademarks, I will briefly mention 2 points, and Enzo has mentioned one of them. The first one is very objective, has something to do with sound marks and scent marks, because of the term called visually perceptible. This would restrict the possibility of protecting this type of trademark. This is highly objective and direct. And also the well-known and notorious trademarks. Enzo has mentioned this profoundly, but very briefly, the difference between a trademark that is considered to be well known, that has to be registered in Brazil, and then it's works for all areas of activity, while the notorious trademark coming from the Paris Treaty doesn't need to have a registration in Brazil, but it only operates in that sector of activity. What we have seen globally speaking is what is being considered abroad is admitting both. It's TRIPS plus, as we call it. It's notorious, but can be applied to all areas of activity. So in Brazil, we need to be aligned with the regulation to see if this makes sense, considering our national interest here in Brazil, which is on the interest of the country. For industrial design, there's one thing: protecting detachable pieces and parts of a whole. There was a CADE decision involving car makers, and part suppliers or manufacturers. Those were the ones that were the holders of rights for the parts. They claimed that the car makers were in unfair competition, and the market should be restricted to brand new cars, primary market, and this should not be applied in the secondary market, and this would have a very negative impact on the development of the car part market, making it difficult for consumers to have access to alternatives of car users. So the decision, the voting was 4-3 favor of car makers who held the industrial design rights and had the rights recognized. And in this case, the manufacturers would have to pay royalties to car makers. For this case should be considered as a benchmark or not. We can maybe take decisions on a case-by-case basis, and every case has its particularities. So in this case, in terms of unfair competition, this could be used maybe for cases under the CADE. For geographic indications, so the need
em duas modalidades, né, dois tipos, que é a procedência e a denominação de origem.
Two types.
E essa indicação de procedência, ela acaba não tendo uma jabuticaba brasileira, né, porque ela
where it comes from,
do lado da Convenção de Paris, e ela é
this was borrowed from the Paris Convention, and it's been boosted with
ele precisa ser conhecido, né?
That the center of production and manufacture has to be well known, but
a qualidade do produto.
There is under the law, there's nothing related to the quality, the technical knowledge, and expertise of the workers in a certain region. So we see that this is not the same anywhere else. It's only in Brazil that is like this. So are we going to maintain this or not? This sometimes makes it difficult for us to recognize some of our regions. Here, in terms of the geographic name, Articles 177 and 178 mention the geographic name of the country, the city, or the region, or the village. We have a classic case of Scotch. It's not a geographic name, but until recently, it was understood as not subject to geographic indication. This has been changed, and maybe we should be asking ourselves if it would be worth changing, because it seems that this is a very restrictive wording for the purposes of a geographic indication. The other one is the sparkling wine. There is no geographic name. There is no association with Catalonia for Cava that produces this type of sparkling wine. So that would not be contemplated by this restrictive definition of the name. Another point I'd like to stress is the control systems. There aren't enough, the PTO, the law is very shy, very timid when it comes to this. The European law treats this in detail. There is the need of control systems that are sounder, more robust. We have to see how to implement this, but this has been a demand from our European partners when we negotiated the free trade agreement. And then finally, given all this, when it comes to geographic indication, our contacts in general is mainly with the Europeans. They are considered to be benchmarks in this. They have thousands and thousands of geographic indications. If we would have a specific law like they have, the section for geographic indication for the free trade agreement is beyond anything else as we can have in geographic indication in our intellectual property law. As for transfer of technology, it's only one point. There is annotations of licensing contracts in technology transfer, Article 62 for patents, annotations on licensing contracts, and for marks 140, Article 140, and technology transfer is the Article 211. We have the Bill 7599, which proposes revoking Article 62. If the issue is excessive bureaucracy, it only talks about Article 62. But it's important to mention that this annotation is important because of tax reasons for deducting income tax, as well as the exchange issues in terms of royalty payments. So anything that we think in this aspect, it needs to take into account these procedures for demonstrating for income tax deductions, as well as exchange rates for royalties. We have trade secrets, which is a heated debate internationally. One of the pillars of the trade war between the United States and other countries, such as China, accusing China of stealing not just intellectual property, but also trade secrets. But for the Brazilian PTO, what we have articles, these items under Article 195, more related to unfair competition. This is very basic. We have seen that other countries have done that. Maybe we should have something more specific to recognize the importance of trade secrets in development, maybe establishing sanction mechanisms, better establishing these concepts related to trade secrets. also because it's a very different nature compared to patents. Patents publish their content. So this is essential, and this leads to some difficulties. So a company may feel damaged because accuses somebody else of stealing trade secrets. When bringing the case to court, they may have to reveal further their secrets. So especially as to the defendant, this is not just happening in Brazil, but it happens everywhere. We have looked at how other countries have done this. In the United States, they have at least 2 laws that deal specifically with trade and industrial secret. And then finally, wrapping up my brief presentation, I would like to stress the sanction. Our law only talks about 1 to 3 years of prison or fine. There is an older bill from '99 that it's a difficult discussion that we need to conduct with society to see if it makes sense to change anything in this sense. And the last point that Gabriel has also mentioned is the other bill that has to do with the structure, the budget structure of the Brazilian PTO, which is the Bill of Law 143 about the budget of the Brazilian PTO. So this is my participation. I'd like to thank you for the invitation. I'd like to thank Gabriel for the invitation. Thank you so much.
Muito obrigado, Dr. Felipe Machado.
Thank you, Dr. Felipe Machado. I should say that I am extremely happy to see the very deep knowledge that you and all members of the panel and other colleagues show in terms of intellectual property. This shows the force and the talent of our public service, of bureaucracy in the good sense of the world. We like to say in Brazil that bureaucracy is negative, but civil servants that are well-trained and qualified, they are crucial, especially in such a large country, a continental country such as our country. And I can say that 20, 30 years ago, it was not so easy to find colleagues that would make a presentation so brilliant, such as the one that you have given us today. Dr. Felipe already said that he had a previous commitment at 4 p.m., so please feel free to leave. And we are now going to hear a fantastic presentation from Dr. Márcia Barros, and you could, and I'm sure you can listen to her presentation later on. We know that the Ministry of the Economy cannot stop, so please, we are now going to give the floor to Dr. Márcia, and feel free to leave since you have to leave. Good afternoon to all of you. I am very sorry that you had to leave, but I understand. And I would like to thank ABPI and in particular Gabriel for this invitation to be here. This is a traditional event from ABPI, and we all regret the fact that we can't be together due to the pandemic, but we do hope that in the coming year, things will be different. but this remote meeting has its advantages. And we have people participating from different locations without the need to leave one place and go to different countries and different cities, which sometimes is not possible.
Sim, estamos.
Can you see the screen, the full screen? I'd like to congratulate my colleagues from the previous presentations, and I've tried to make a presentation along the lines that Gabriel mentioned at first. The political options that shape this area, they tend to be well respected, but it is also very pertinent that ABPI follows and monitors developments in Congress and makes contributions. So in my analysis, I also wanted to share with you certain changes that could make life easier for all of us who work with intellectual property. And let me start highlighting one aspect that Gabriel also mentioned. Our law has aspects that can be further improved, but it is very substantial and it has many positive aspects. And I believe we have to see in a focused way what can be improved. And in terms of the more debatable points, especially in the area of patents, all these aspects have already been the object of many discussions, including in court, and there are many lawsuits now being considered by judges, and decisions will be handed down. And we've had discussions in which we had members of our Supreme Court participating. And this is in relation to the constitutional aspect that was discussed. We also have the pipeline patents, and we have the mailbox patents, and the decision from Anvisa, which is not yet a final decision. But these are topics that have been intensively discussed during these 25 years of our law, and they are still being under scrutiny in different instances. So let me focus on more practical aspects of our daily life in different areas. On patents, and of course, I may be repeating what has been said by my colleagues, but let me try and focus on the main points. Article 32. Here, I would like to introduce a correction to what Gabriel said, because in fact, Article 32 still brings about problems. It still deserves being further improved. In the international practice, we can see how amendments can be made, but we have to think about a time limitation, whether this time limitation, what type of time limitation we will have. We are still having problems because we had a public civil lawsuit that was judged at the trial level, but at the appeal level, the claim was judged as being founded, and the court understood that the request went beyond what had been established by the Brazilian PTO. So there was a requisition for execution. This was denied by the judge, and there is a pending appeal in the court. The rapporteur said that this should not be actually considered as an appeal, but rather as a motion. And so this issue has not been settled yet, and it would be very positive if we could have a better understanding of this article and a better definition of this article, so that we can have a definition of what can be changed, what are the possible alterations, and as Gabriel proposed, whether this would be, whether this would go up to the administrative level. I think this should be better reviewed and established so that no further legal problems arise from that. Another point that I think may bring about problems is Article 56 that limits the nullity action. Because here we have a factor that may be demanded in court when the effectiveness of the patent is about to expire. And in this case, there would be no relief for any defense. What we have is not a majority position, but there are precedents. And in this case, the nullity could be argued even after this effectiveness. And another question that was addressed by Felipe, I don't know if the world is already ready for that, but in some countries, we have artificial intelligence. I think in South Africa, in Australia, patents were granted related to artificial intelligence. I think we should get ready for all these technological possibilities. I don't know whether this is the right time, but we do have to be mindful of such developments. More and more, we are going to be dealing with non-human intelligence. And one point that is criticized by lawyers, and it is a polemic topic, and I would like to ask you to think about it, is the broad cognition in terms of patents. Because if our law establishes that in administrative procedure, not even the extension will end up with the nullity action. So if during the administrative exam of the patent, if at any point a requirement can be verified, all requirements can be verified, why couldn't we carry out this broad cognition? The Superior Court has shown the possibility of agreeing with this broad cognition in which all patent requirements would be analyzed, although they had not been specifically challenged or questioned in the initial petition. And for those who appropriately have a criticism on that, I'd like to remind that intellectual property is a very specific realm of knowledge, very different from public law and private law, which are the concepts in public and private law are always not in confrontation, but they are mixed, because here we have in patents a private law, but there is also exclusion from public domain. So specifically, and especially now, with what is happening to Article 40, I think more and more we have to have expedite systems for patents in court situations. And I believe that broad cognition would favor both the patent holder, because then the patent would be confirmed, and also the other parties, so that certainty could be assigned to the patent and establish whether it's valid or not. In terms of industrial design, and Felipe mentioned one important point, which is the different proposals that exist. I think we are not yet in a position in which industrial design would go through a merit exam as patents. But I believe that the preliminary examination should be qualified so that certain basic requirements could be considered, such as the configuration and external configuration and the visual result. We've seen cases in which industrial designs are not going to be seen by anyone because they are inside a cover that will go in an element that will go within the wall. So I don't know if that responds to this need, and I think it's questionable that this responds to the requirements of Article 95 in terms of external configuration. We could have it better qualified in this sense. On trademarks, in addition to what has been mentioned so far, I think that any change in trademark legislation should take into consideration non-traditional trademarks due to the technological progress that we are experiencing. So it's not only the sound and scent trademarks, but many other possibilities should be considered, and these possibilities are not being taken into account. There are multisensorial marks that you have to use tactile elements, visual, and other properties that include vibration, viscosity, stickiness, and all that could be further increased by augmented reality or virtual reality. Therefore, we should be ready to face the reality of non-traditional trademarks. Another point that I believe deserves an update is Article 124, Item 3, when it refers to signs contrary to morals and good customs. I think this type of open-ended concept is not applicable. The legislation should refer, for example, to non-discriminatory figures or expressions. So there are certain expressions and figures that should not be allowed in trademarks. And I'm talking about expressions and figures that imply discrimination of race, religion, faith, or that in any other way are an opposition to this type of freedom. And I think this should be seen in a different perspective. And the Constitution mentions discrimination and prejudice. Therefore, this should be included. Article 5, I think here it's not a change in the legislation. The problem is that we need an integration of systems. This has been in need for many years. We have to have a roster, a national roster, in which information can be shared. We do have jurisprudence on that, but we don't have a unifying jurisprudence. So we remain in a case-by-case review according to the activity, according to the location. So I think this could be improved, but not necessarily a legislative change, but rather an integration of existing systems. We would eliminate this possibility of confusion that exists in the eyes of the general public. Now, 124, item 6, this is again not a matter of legislative amendment, because this disclaimer has never been in the law. But the idea is that certain change is deemed necessary because this is done today in a way that raises many questions, and therefore it should be dismissed. We could better understand and see what are the items that should be included, because much uncertainty and questioning is generated today. And also the telltale principle of the that relates to the generic aspect that is related to nationality, to nature. This ends up being granted in systems abroad, but it's usually rejected in Brazil. So I think an alternative should be considered so that we could include the telltale principle. 124.9. I think a remission should exist. Often we see some confusion, even jurisprudence, saying that geographic names cannot be registered as trademarks, and this is not what the law indicates. The geographic indication is what the law establishes. So I think this could be made clearer. Our very dear 124-19, which accounts for most of our judicial demands. It generates, up to today, questions not about the article itself, but the holder of the registration, the owner of the registration, and whether they should participate in the suit or not. This was discussed in a recent conference. The third commercial law journey. And in spite of all the discussions, there is still a lot of polemic, but this does not prevent the holder who's not interested in this particular case. It does not prevent their participation, but I think they should be called so as to prevent any decision that runs counter his or her interests. But at the same time, I think a very detailed analysis should be carried out, because there are circumstances in which we don't see any reference to restraining and prior standing. So this should also be taken into consideration. And in addition, there are certain prior situations that can hinder the process, and we have to define exactly what are such prior situations that represent an impediment, and not carry out a separate analysis. The way it is as if, well, if we are able to overcome this set, then we go to the next one, and I think we should consider everything as a whole. And I'm not going to dwell on that now, but the fact that the notorious trademarks, since all the three speakers decided to touch on notorious trademarks, this is already an indication that the law can be improved. And let me call your attention to one aspect when we talk about notorious trademarks. This is the prospective effects that it may have. Jurisprudence is considering that, and such trademarks have to be taken into consideration with everything that has been granted in the past. And the right of precedence, please, Gabriel. This is something that I believe is already under consideration, but such a right, when the moment in which such right can be exercised is not well established, this preferential right, and we know what existed in the past in terms of the legislation determining that such preferential rights had to be applied only under certain circumstances and a certain time period. Then there was a change in the legislation. And with all due respect to the decision, after this decision from our superior court, I believe that the amount of suits that we've received claiming such right has increased significantly. So I think it has to be better established when such a right can be exercised. Questions related to secondary meaning and other issues could also be addressed in legislation. On forfeiture, there are 2 points that I would like to highlight. And here it's the non-use of the trademark that leads to that. So Article 143.1 says, use of the mark in Brazil has not been initiated. Now with the internet, all possibilities of trademark use have changed. And it is my understanding that the possibility of proving use could be better defined. And another issue is the updating of the mark, depending on several factors, including as time elapses, certain aspects must change, and this should be better defined in the legislation. Another point, which does not require a specific change, but it is urgent that we act on that, it is the transposition of old records that have been renewed, are being renewed without being moved. And this should be carried out because we still have many lawsuits in which the existence of a national classification will generate problems. There are requirements that are totally ungrounded, which are the result of the national classification that has not been properly transposed. Now let's turn to crimes. In spite of the fact that I agree with the need of protecting trade secret and business secrets, my perception is that our criminal legislation already complies with the main principles, and no matter how important certain aspects are in terms of intellectual property, I think they should only be ruled by the criminal code in cases that the other realms of law are not able to provide the necessary coverage in terms of, otherwise it wouldn't be necessary for intellectual property. Certain procedural issues which are very relevant in our daily activity. The first one is the intervention by the Brazilian PTO. Such intervention should be treated pursuant to the majority of the jurisprudence. So, the Brazilian PTO would be the defendant, and there are cases in which it would be assist the plaintiff. And there's a very successful experience with Decree 08285 that established a new system for the Brazilian PTO. It's only after the contestation. This was the object of many conversations with different agents, including the Brazilian PTO, and it is a system that is working very well because the Brazilian PTO, which is an autarky, which should be equally distant from the interests of the parties and has an independent standing. Therefore, it should be interesting for the Brazilian BTO to have the arguments of both parties before any manifestation is presented. And I'd like also to mention the suspension and all the confusion in terms of the federal and the state justice. We have the wording of that was reached during the second journey on commercial law. There are situations in which we've discussed the requests for nullifying, and here there are very significant reasons. The fact that it's not being used, or in terms of the decision of our TRF number 2 that is now accepting this possibility of use. For me, it makes sense. I believe that after being a party in a lawsuit in our court, and if that party has to go through the whole process at the federal level, having to go through a similar system in the state level would be excessive hard. And another point is situations in which there is a request to nullify the process in the federal justice. In terms of foreign holders, my fear is exactly the opposite. I think that we fear that this will somehow be dismissed, will disappear. We've seen that when we've discussed the Madrid protocol, but we've also talked with different agencies so that there won't be a need to change this provision. If we consider today a rogatory letter, and if we require a rogatory letter, this would certainly delay all procedures. No legislative change in our law will be effective unless we are able to modernize our systems, upgrade technology, have financial independence, and be in a position to hire new civil servants. If we are under threats of placing the Brazilian PTO under what in Brazil is called the S system, if we have such an impact, we will not be, if we are under distress, we won't be able to have a strong system. And I was looking at the INPI, the Brazilian PTO site, at a review that was carried out in 2017, and of course this is already outdated. But when we look at the numbers, we are surprised. I think we are impacted, and we see that we can no longer keep it the way it is. When we think about the action of inconstitutionality. Although it was not considered in the final considerations, we have to think and see that the numbers indicate that things are not running properly in this sense. If we consider that we have 27 examiners in the first level that are responsible for pharmaceutical patents, we see that it's impossible to work with such numbers. We have 17 examiners in civil engineering and mechanic engineering. Chemical engineering, only two examiners. These numbers are blatant. And if we are to review here and see the average number of new cases by year per examiner, we are going to see that in the pharmaceutical area, we are going to have an average of 57 new cases per examiner, which is a very high number, well above the international average. But in most areas, pharmaceutical, organic chemistry, telephone, engineering, in all those areas, number exceed 150 cases per year per examiner. In some areas, it may reach 200. And there is one in particular that impressed me, which is the biomedical area, 342 patent requests per examiner year, new cases. These are regrettable numbers that we are faced with. I believe the federal government should invest and invest significantly in hiring new civil servants. In spite of technology and artificial intelligence, we need human intelligence to analyze the patent applications. And to conclude, let me just leave you with an idea. All those who work in the area of intellectual property and cherish the specialization that took place in our courts, not only my court, but also other courts that attribute value to it, and can see that the quality of the decisions, the fact that the procedures have been expedited and there is more legal security. But in addition to that, I would like to present a suggestion, which is a topic that has been covered here. It's the project Justice 4.0, the idea of having centers, individual centers. The pandemic has forced us to consider certain things which were deemed to be impossible as possible. So based on this idea of dematerializing courts and having a quality judicial service being done online, I believe that it will also be interesting to consider such centers, justice centers. We are talking about the first level, the trial level, but we should consider a international intellectual property court 4.0. This 4.0 court would be precisely appropriate for intellectual property because we work with innovation, technology, and this could be considered. We could use as example the courts in the US in which you have certain courts, and all IP cases would go to these specialized courts, and we would have state and federal decisions. That would certainly contribute to the quality, to the time frame, and to the security of the results, in addition to accessibility and visibility. If we were to have a totally virtual court, and in addition, this would further strengthen the system. And here, I close my presentation, and I'd like to congratulate once more ABPI, because I do believe that ABPI is one of the main pillars, one of the main engines that are driving the progress of intellectual property, and has been doing so throughout its existence. Thank you.
Thank you very much, Marcia. It's always a great pleasure to hear how pioneer you are. For those who don't know, Marcia Maria Nunes is the main developer of the testing for measuring creativity and invention activities in Brazil, something that is well developed abroad, with the idea of a court 4.0 specialized in intellectual property, shows how pioneering her attitude is, and it gives us food for thought on what we can have in the future. I only want to make 2 comments. Unfortunately, I will have to give the floor to our president to close the meeting. Marcia mentioned a problem that ABPI anticipated, which was the bottleneck in reclassifying trademarks. When the international classification was adopted in Brazil in the end of 1999, ABPI said, we shouldn't do this for all the pending processes. Let's do only reclassification, only for renewals, like South Korea had done at the time. The international classification, we were not heard, and until from 2000 to 2006, it was major chaos. Chairman George Alvila very rightly decided to requalify. Let's continue with the 2 classifications together. If we had heard in 2011, everything would have everything reclassified. So the Brazilian PTO should determine that the holder should reclassify when renewing, and it would be the decision of the VRPTO to decide if the is right, and then in 10 years we'd have a single classification system here. As for the need for more examiners, Your Excellency knows this is also something ABPI has defended, had advocated. We're not replacing examiners by computers because there's no money. We need money to buy machines. In the beginning of this Congress, the chairman said he needs 20 million reais for further automation of the RPTO. And then Gasaranha said 20 million is just the beginning. At the end of the day, in terms of artificial intelligence and system for Brazilian PTO is much higher. We know that the Brazilian PTO has money, and ABPI is very concerned with this, and soon we'll have news to inform the whole system of intellectual property as to this topic. Well, I once again thank you, and now I give the floor to President Pimenta to wrap up the Congress. And already congratulating him, I know as a vice president, I'm part of the organization, but I'd like to congratulate him wholeheartedly, and I am sure we do this on behalf of all members, because this his last Congress after 2 terms. He is going to end his 2nd term at the end of this year. And at ABPI, we cannot, just like the federal government, cannot renew a further than a 2nd term. I would like to thank him and Erica Denise, our executive director, who worked so hard to organize this great event, and the full team of BPI. I then give the floor to Luis Ediguar, and I thank everyone, to all of those who have participated. Thank you so much for your kind words, Gabriel. Before I wrap up, I would like to thank the speakers for the brilliant presentations. Topics have been dealt with in depth. We would be able to continue this through a webinar or in a smaller event with the presence, physical presence of everyone, because the topic is still not exhausted. I'll give you an example that I thought that when Dr. Marcia was speaking, we are now orphans under this law. The slogans, the issue around the slogans, in practice, INPI grants an advertising, and then we can see the use, and sometimes it's denied. Sometimes it's just a sentence. Sometimes, for example, it's just a slogan, enjoy. Obviously, it's advertising, but it was registered as a trademark. So these questions, there are questions around these issues, and then
history of the economy, and highlighted the importance of having the Minister Guedes with us. So this was very important for ABPI. I also would like to reiterate what Gabriel already said, which is our thanks to the organizing committee. My thanks to the lecturers, to the participants, to the executive director, Erica, Denise, her team, and all support staff. And let me conclude repeating the final words of Minister Guedes. The government stands against the breaking of patents, which for us is very important, and also the words of Judge Marcelo Tavares, now repeated by Dr. Marcia. And he said, the effort and the fight of a lifelong on behalf of intellectual property, and this fight has been undertaken by ABPI. So these were great words to hear. And before I give the floor to Erica to conclude this Congress, I would like to say goodbye to you, hoping that next year we will have in-presence conference. Thank you. I'd like to thank all of you. And we do hope to be together in 2002 when we will have the next Congress of ABPI. Thank you.